Hi, I'm David Tarras, partner at the Rossen Law Firm and head of the Federal Criminal Defense Practice and the White Collar Federal Criminal Defense Practice. We're here today to talk about one of the most commonly indicted charges in the federal justice system, which is conspiracy. Now, conspiracy breaks down into multiple different subsections. But from a very general standpoint, a conspiracy is, while very difficult to be facing because almost of how broad it is, at its core, conspiracy is an agreement between two or more people to commit a crime or a fraud against the United States government. When a federal prosecutor brings an indictment or begins a federal criminal investigation for conspiracy, what they are alleging, what they are trying to prove is simple. It is that two or more people made a conscious decision together to commit a crime. Now, what that crime might be is called the predicate offense, and it can be a very wide variety of crimes. But the federal prosecutors, the Department of Justice, uses this conspiracy, which is basically just a crime that involved two or more people. Hey man, let's commit a crime. Prosecutors have conspiracy. And it can create real rifts in a case for a lot of reasons. Prosecutors love conspiracy because all it takes is two people, and then you have co-defendants, you have their attempts to pit them against each other, to get some to cooperate. It can get very complex. You need experienced federal criminal defense attorney to be able to walk you, guide you, and protect you through this very murky, very gray area of conspiracy. Because sounds simple, but when they tack it on to something else, as they often do, tacking it on to smuggling, conspiracy to traffic narcotics, to commit a Hobbs Act robbery, to commit healthcare fraud, to commit violation of the anti-kickback statute, whatever it may be, they will use that in order to strengthen their case because it's just one more tool in their toolbox to say, hey, Mr. Jones, we got you. Well, guess what? You hire us, we understand conspiracy. We understand the internal policies as to why the federal government says, you know what, can you get two or more people on there because then we can hit them with conspiracy, and then it becomes so easy to prove. The way it works, the dynamic, and why it's so different than other charges is they don't actually have to prove the underlying crime. They can just prove conspiracy. You can actually go to trial on conspiracy to commit healthcare fraud, conspiracy to commit wire fraud, conspiracy to commit money laundering, conspiracy to commit arms dealing, whatever it might be. The prosecutors can fail. We can beat them on the underlying charge, what we call the predicate, but they still have the conspiracy. And all that conspiracy in their mind takes is just two people agreeing to do that predicate offense. We lose the predicate offense. They can't prove that beyond a reasonable doubt. Well, can we prove that they at least two people tried and made some plans to make that underlying offense happen? Well, then we got them. That is what you need to be protected from. And one of the scariest things about conspiracy charges when they're brought by the federal government is when conspiracy is charged, it creates an interesting dynamic, a very interesting dynamic, because there's no requirement for the government to prove that the actual offense occurred, just that there was agreement for the offense to occur between two or more people. Scary part, the penalties for conspiracy often are the same as the penalties for the underlying offense. So that being said, there are elements of conspiracy that they still have to prove. It is not as simple as many federal criminal defense attorneys and many prosecutors and the Department of Justice make it seem. What does the prosecutor actually have to do in order to prove the charge of conspiracy? There are a few different conspiracy statutes. Generally speaking, you'll have a statute where the government needs to prove that two or more persons entered into an agreement to violate federal law, and that agreement was joined by each individual knowingly and on purpose and not by mistake or accident. On the other conspiracy statutes, which is one that defense counsel argues for, defense counsel such as ourselves in federal criminal defense cases will argue that there is one more necessary element, at least one more necessary element for the prosecutors to prove beyond and to the exclusion of all reasonable doubt, which is that one or more members of the conspiracy made what's known as an overt act towards the ultimate goal of the conspiracy. The overt act being they took some sort of action, took some sort of step in furtherance of the planned crime, whatever the crime might be. Defense attorneys and experienced federal criminal defense attorneys will want to argue and will want to make sure that that crucial element of an overt act be taken into consideration and be required, a requirement that a federal prosecutor must prove in order to find our client guilty, in order for us to not beat your case. Even then, we can beat it. But we want that overt act element to be there. Now, different districts, different courts differ on whether an overt act is required. The general consensus, and in the Southern District of Florida, an overt act towards the conspiracy is required. So John Doe texting Jane Smith saying, let's commit a federal crime would not be enough. There would have to be one more step. If the crime was to defraud a healthcare institution or a financial institution, the law that we argue as it should be read is that there should have to be an actual step taken to do that. Just communicating, just planning is not enough. An example would be actually going and starting to meet with the healthcare institution, meet with individuals, doctors who might be willing to join the conspiracy to make the overall plan work. But it is crucial that you find an attorney such as ourselves, the federal criminal defense attorneys at the Rossen Law Firm, who will defend you and hold the government to that overt act requirement. It is so commonly missed when lawyers are defending their clients against conspiracy charges. Why is federal conspiracy such a common charge? Why do they attach this to so many other predicate offenses that we talked about? This is scary, and it can really cause you a lot of stress, anxiety, and unknown when facing this charge. Because believe it or not, as wrong as this might be, if there are multiple people alleged to have been part of a scheme to defraud, white collar or not, it only takes one member of a conspiracy of individuals to commit an overt act for all of the individuals charged as co-conspirators to be drawn in. Conspiracy to commit offense. The General Federal Conspiracy Statute, 18 U.S.C. 371, if two or more people conspire either to commit any offense or to defraud the United States in any manner or for any purpose, and one or more people do any act to effect the conspiracy, that is that overt act we talk about, that requirement that we cannot forget about. They can be fined for an imprisonment of up to 5 years. That is the penalty. Statute sounds very broad. There are a lot of defenses to this. There are a lot of ways to say you cannot prove that two individuals or more actually had a cognizable plan in place. That's why the overt act requirement is so important and one of the most common ways that we will beat our clients' conspiracy charges. What are some of the best defenses that we can possibly have? One is simply creating reasonable doubt. As easy as the prosecutors might think it is to prove a charge of conspiracy because of the way that the statute is written, there are several ways that we can fight them. Of course, you have the right to counsel. You have due process. You have the right to a fair and speedy trial. You have the right against self-incrimination. You have the right against unreasonable search and seizure. But when it specifically comes to a federal conspiracy charge, we have to put the prosecutors to the task. One thing that many lawyers forget and prosecutors overlook is that a co-conspirator must first have conspired, meaning agreed to the accomplishment of the criminal object, of the criminal action. Listening to another speak about a potential crime is not a conspiracy. Even talking about a potential crime is not enough without some sort of agreement, some sort of overt act in furtherance of the conspiracy. Remember, it takes only one conspirator's actions for all conspirators to be held liable, to be held guilty. If you've been contacted by the federal authorities, if you realize that you are under criminal investigation, federal criminal investigation for a conspiracy charge, please do not hesitate to contact us immediately. You need a federal criminal defense attorney who can come onto your case right away, prevent any sort of investigation or prosecution from getting any head of steam under it, and properly protect you, so that you and your family can be safe and not fall victim to these terrible catch-all federal criminal statutes. Prosecutors think they have a loaded gun on these. Well, we'll show them otherwise.